So, just before you start, thank you all very much for agreeing the timetable. A couple of points on that. One is, unless the transcribers ask for one, in this court we don't normally have breaks for transcribers. Is that going to be all right? So that in one sense provides a bit more time. But on the other hand, we wouldn't propose to sit beyond 4:15 on any day. So that doesn't affect the cut-off points for your respective submissions. And I should say to the transcribers, if you get into difficulties, can you please tell us, and we will then introduce some breaks. Anything else we need to raise before you get underway?
My Lord, no.
Yeah, please do that.
My Lords, these are three conjoined appeals against the order dated the 22nd of September 2021, made by His Honour Judge Davis White, Queen's Counsel, in the two listed conjoined cases. In case number 44561, I appear with Mr. Levy for the Appellants, Mr. Schofield and Rhino Enterprises Holdings Ltd, appealing against the striking out of their claim against the former joint administrators, for whom Mr. Smith, Queen's Counsel, and Ms. Thornley appear. And in the case 3993, Mr. Levy and I appear for the Appellants, Rhino Enterprises Ltd and Askwith Investments Ltd, appealing against the partial striking out of their claim against Clyde Co, for whom then friends Mr. Curl, Queen's Counsel, and Miss Julian appear. The third appeal is brought by Clyde Co in the 3993 case against the judge's decision not to strike out the entirety of the claim against Clyde Co. And your lordships will have seen that the parties appeal with permission of the judge. My lords, there should be a core appeal bundle with pagination prefaced by the letter A, including relatively new tabs 26 to 32, which in turn includes a short supplementary skeleton, which I believe tab 26 the court gave permission for last week.
I'm sure we do have those. I'm not sure I've got them in quite that form, but as far as I know, we've got all the material.
Well, we have them in, as new tabs 26 to 32, yes. And I'm very sorry if that's not the case.
No, that's fine.
There's also a supplementary appeal bundle, that's B, as it were. And I hope you have a combined authorities bundle in 3 parts.
Yes.
The judge's judgment is in the core bundle, obviously behind tab 12, and the settlement agreement you'll find behind tab 25. My lords, the grounds of appeal, grounds 1 to 4, relied upon by my clients in both of their appeals, whereas grounds 5 to 7 relate, you'll have seen, to the ex parte James point, which is only relevant as between me, as it were, and Mr. Smith, Queen's Counsel. You have our main skeleton, I think, behind tab 4, page 47, and I'll refer to that, if I may, as our main skeleton. The settlement agreements, which we can take up behind tab 25, page A445. It is obviously the subject matter of the appeals, and its interpretation is what your lordships are being asked to determine by reference to, obviously, the judge's judgments, but also looking at the matter afresh as a matter of interpretation. You will have seen that its terms were negotiated late at night on the 30th of December 15, and I think signed sometime before 1 o'clock in the morning on the 1st of December 2015. And before analysing the disputed terms, I'd like just briefly at a canter to look at it generally to see its structure, and if I may suggest that it's relatively conventional in structure. We have the parties clause on page 44 of the bundle. The first 3 parties are the claimants in the litigation against Barclays, and obviously Barclays was the 4th. We then, in the introduction, in the recitals, we see it describes the dispute that was being settled and that the settlement took place at the mediation, and that the dispute was between the parties, as it were, namely the claimants, the first three parties' disagreement, and the defendant, and that those parties, recital B, have agreed to settle the dispute on the terms set out in this agreement. And then at clause 1.3, you will notice that reflecting the party lines in the litigation, the obligations under the settlement agreement of the three claimants were lumped together as against the defendant, such that they were jointly and severally liable for those obligations to Barclays. Clause 2 then has the full and final settlement and agreed discontinuance provisions, and obviously clause 2.1 needs to be looked at closely, and we'll come back to that in due course. Clause 3 has some concomitant releases of claims and the usual provision to prevent contribution or ricochet claims by two methods. The first method, 3.2, was a covenant not to sue, and obviously the issue is whose obligation and not to sue whom. And then 3.4, if that covenant was breached, an indemnity for costs and damages caused by any such breach. And we say they are the conventional ways of dealing with contribution or ricochet claims. At clause 4, you'll notice that the Barclays pays an unallocated settlement sum simply to the claimants, again representing the alignment of the two sides. And at clause 5, there are no admission clauses, confidentiality at clause 6, an entire agreement clause which is relied upon by my learned friends, clause 7. And then clause 8 is the operative provision for deciding whether or not my learned friends' clients can sue upon clauses 2 and 3 of this agreement. In broad terms, they say they're within clause 8.1, we say they are caught by 8.2, and the reason is that they say that they are our affiliates, as it were, and we say that they are not, and or that there were no releases of them in terms of no internal releases, and I'll come back to that. And then the rest of the agreement is, I think, entirely a matter of form for present purposes, containing the sort of things you'd expect. That's the broad structure of the settlement agreement. As for the background facts, the relevant background facts that led to that settlement, in his judgment, behind tab 12, page A160, at paragraph 41, the judge summarised the claims that were made against Barclays, which were settled by this settlement agreement. And I'm not going to take your lordships through it. I've no doubt you've got the scope of it in your mind's eye. In particular, the judge described in some detail in his judgment the mis-selling claims and the claims relating to the OpCo-PropCo structure, all dating back to the late 2007 to 2010. Before looking at the terms of the settlement agreements, could I suggest that there are two unusual features of this case? First, that it, we say, purports to, on my own friends' cases, affect internal releases by a party to the agreement of its own affiliates. In that respect, we of course accept that there are many reported cases in which the court has been asked to determine disputes about the meaning and effect of a settlement agreement, which compromised earlier disputes between the parties. And in all such cases, the common feature of the dispute about the settlement agreement is whether the claimant's subsequent claim is caught by the earlier settlement. And typically the defendant alleges that the compromise was comprehensive and the claimant alleges that it was partial, and that it did not extend to the new claim. By contrast, in this case, there is no question but that the claimant's settlement with Barclays was comprehensive. The settlement companies are not attempting to sue Barclays. They accept, to use the phrase adopted in BCCI and Ali and in many subsequent cases, that as between them, the settlement agreement wiped the slate clean. Nor is it in dispute that the parties to the settlement agreement gave each other full protection against contribution claims. Looking at the protection given by the settlement agreement to Barclays, they agreed to ensure that none of their affiliates would make a claim against Barclays. But in case they couldn't achieve that, they gave Barclays a comprehensive indemnity should such a claim be made nevertheless. What is unusual about this case, and as far as reported cases are concerned, we believe unique, is that it's alleged that the terms of the settlement agreement should be interpreted as having affected what we've termed internal releases. Releases by each party to the settlement agreement of all claims against its own affiliates. And if that is right, it does so by reference to the widest possible definition of claims and liability. It's alleged by my learned friends that the parties, and the judge accepted, that the parties have compromised a very wide range of actions and claims against their own affiliates, to the point where they may not even make demands or take regulatory proceedings against various persons. We say that even if the protection of clauses 3.2 and 3.4 had not been agreed, the extent of the alleged releases would far exceed what would be required to protect Barclays against contribution claims. My lords, the other and second unusual factor in this case relates to the question of admissibility of evidence. Admissibility by reference to the relevant surrounding circumstances, the contextual element of the process of interpretation. The court is, particularly this court, particularly well known, are well aware of the applicable principles for interpreting contracts and of the unitary exercise that's, as it's now described, of interpretation. And the question on this appeal, or these appeals, relates to the admissibility of what was said by the parties for a long period prior to the mediation and confirmed at the mediation, and the extent to which that is admissible. And if I could just ask you to take up the authorities bundle, file 1, part 1, and behind tab 3, within Sir Kim Lewison's book, we could just invite you to go to C28. at the foot of the page, the debate, picking up, this is within his extract on admissibility or otherwise of pre-contractual negotiations. He says, the debate may in time shift the question of whether the evidence sought to be introduced is directed towards establishing some objective fact or is merely evidence of subjective intent. And then there's a quotation from Lord Clark in Ocean Bulb. Trial judges frequently have to distinguish between material which forms part of the pre-contractual negotiations, which is part of the factual matrix, and therefore admissible as an aid to interpretation, and material which forms part of the pre-contractual negotiations, which is not part of the factual matrix, and is not therefore admissible. This is often a straightforward task, but sometimes it is not. And then at 3.51, Sir Kim refers to some of the cases where evidence of negotiations has been held to be admissible. And obviously at this stage we're just dealing with general principles and not the facts of any given case. The first case he refers to is a Scottish case where Lord Roger in Bank of Scotland's and Dunedin property, having considered the English authorities, said, as these authorities demonstrate, a rule which excludes evidence of prior communings as an aid to interpretation of concluded contract is well established and salutary. The rationale of the rule shows has no application when the evidence of the parties' discussions has been considered, not in order to provide a gloss on the terms of the contract, but rather to establish the parties' knowledge of the circumstances with reference to which they use the words in the contract. And then there's a reference also to the Delford decision in New South Wales, where the Chief Justice Mason said obviously the prior negotiations will tend to establish objective background facts which were known to both parties and the subject matter of the contract. To the extent that they have this tendency, they are admissible. Now, it's instructive just with that background to reflect on the following facts in our case. We accept that there is not always a bright line between words or conduct that are admissible and those that are inadmissible for this purpose. But I would just remind your lordships of this. First, there's no attempt in this case to rely on the drafting history of the settlement agreement. Nor is there, secondly, any attempt to give direct evidence of what the parties to the settlement agreement intended by the very language used in it. And I'm sorry, it was the third nor, but nor is there an attempt to rely on matters within the knowledge of only one party to the agreement, which, as Lord Hoffman in BCCI and RLE pointed out, would be admissible. But there is the unchallenged evidence of Mr. Schofield, which we have in the supplemental bundle at tab 6, page 227, to the effect that it was known and acknowledged by all parties to the settlement agreement for some considerable time prior to, and then acknowledged at the mediation, that Barclays would not negotiate and were not negotiating any claims that the companies had against the joint administrators or their advisors. And any such claims were for the companies to take themselves. As a result, there was not before the judge, and there is not before your lordships, a factual dispute about the facts known to both parties entering into the settlement agreement. Rather, there's the unchallenged evidence of Mr. Schofield of what we contend are highly material facts known to all the parties to the settlement agreement. Now, the learned judge, in his judgment, if we could just turn to that, in file A, behind page 170, behind tab 12. he relied on the summary of the authorities given by Mr. Justice Jacobs in another case about the interpretation of a settlement agreement, Global Display Solutions Limited. And one can see from paragraph 75 of the judgment, quoting from Mr. Justice Jacobs, that he, Mr. Justice Jacobs, in turn relied on the judgment of Mr. Justice Popplewell in the Lukoil decision, which is quoted in Chitty, as a still further summary, and a very popular one, if I may say so, of the unitary exercise and its component parts in the process of interpretation. And cutting through it, the unitary exercise involves synthesizing two main approaches, what Lord Hope in Wood Capita calls textualism and contextualism. Textualism obviously concentrates on the words used, both the disputed words and the words in the contract as a whole, and contextualism on the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract. And in cases where the words are ambiguous, resort can also be had to the commercial purpose. And it's also clear on the authorities, and was repeated by the judge by reference to what Mr. Justice Jacobs said in Global Display, that given the unitary nature of the exercise, it's not necessary to start with the words with textualism and finish with contextualism, or start with contextualism and finish with textualism. What matters is the balancing of the two, having done both. Now, staying, I'm afraid, before we go to the words of the agreement and analyse them, can I now invite you to reflect a little more on settlement agreements, because they are, to some extent, esoteric. It's accepted, and indeed it's settled, that there are no special rules for interpreting settlement agreements. And that's been established for many years and was reconfirmed in the House of Lords in BCCI versus Ali. That said, the courts are aware that it is customary in settlement agreements, especially during litigation, to use broad language with a view to trying to cover every eventuality. And that broad language and that propensity has given rise to a body of case law in which the courts have repeatedly emphasized the relevance of context of factual matrix when assessing the meaning and effect of, in particular, general releases or settlements that are couched in the broadest terms. The process by which context is assessed in relation to those sorts of settlement agreements with very broad releases and terms, we would suggest can be usefully seen by reference to the judgment in this court in the case behind tab 31, Kazemini versus Siddiqui. In particular, in the judgment of Lord Justice Moore-Bick. And we go to this case because it's just a useful insight into the approach to settlement agreements in particular and the relevance of context. you can see from the first paragraph on page C536 that the dispute was between Mr. Siddiqui and Mr. Kazemi. 10 parties. There were 10 parties to the settlement agreement. It settled on the first day of trial. The dispute, paragraph 2, arose out of the provision by Mr. Kazemini of part of the finance needed to enable the commercial exploitation of, I think they were electric black cabs, which Mr. Siddiqui had developed. And you'll see that the finance was provided also by another investor, Mr. Grano. And what happened was that after this settlement, Mr. Kazemi took an assignment of Mr. Grano's claims, and Mr. Siddiqui attempted to rely on the settlement agreement to strike out the second proceedings by Mr. Kazemini. And you'll see the last two sentences of paragraph 2. At the time of the trial, Mr. Grano had intimated various claims against Mr. Siddiqui. Neither he nor any of his companies was a party to the proceedings. At the time the agreement was made, he was present in London, having come to the country for the purpose of giving evidence. Then the settlement agreement appears at paragraph 3. It's clause 5 of that agreement. It's in very, very wide terms, full and final settlement of all and any claims, actions, liabilities, and so forth the claimants have or may have against the defendants, whether past, present, or future, whether or not known or contemplated at the date of the settlement agreement, arising or in any way connected with the proceedings, or with any dealings between the parties concerning loans to or investments in the defendants, or FNT, or Metrocab by the claimants, or by any person whosoever. And the question was whether those last words covered Mr. Kazemi as assignee from Mr. Grano. And in paragraph 4, one can see that the deed of assignment that was entered into subsequently, and that Mr. Kazemi then issued his second separate proceedings. In the last sentence of paragraph 4, you'll see they followed closely the first set of proceedings. There was then the application to strike out, and counsel for Mr. Siddiqui effectively emphasised, as we see in paragraph 6, the exceptionally broad language of clause 5, and second part of paragraph 6, the submission is recorded that it must surely have covered every possible claim, and that it was in order to achieve a clean break. Jumping to paragraph 9, if I may, Lord Justice Biggs said the problem of deciding what the parties intended by the scope of broad language of this kind has troubled the courts on many occasions. In BCCI and RLE, House of Lords confirmed that settlement agreements are to be construed in the same manner as other contracts. That involves interpreting the words used by the parties in the way in which they would be understood by reasonable persons who are aware of the factual background known to both parties. The judge referred to the case of Arbuthnot and Fagan, in which Lord Justice Hoffman pointed out at page 1403D that whenever words such as in any way connected with are used, it's necessary to ascertain the degree of connection which the parties had in mind. An exercise that can only be undertaken by reference to the context in which they are used. The need to undertake that exercise is not removed by the use of the expression in any way. In RLE, Lord Nichols expressed the matter succinctly in this way: the scope of general words of a release depends upon the context furnished by the surrounding circumstances in which the release was given. The generality of the wording has no greater reach than this context indicates. And then, again, returning to Mr. Miles' submissions for Mr. Siddiqui, at the foot of the page, it can certainly be said that the claims being made in the present proceedings are closely connected to the previous proceedings and the dealings between the parties out of which they arose. But as Lord Hoffman and Lord Nichols have observed, the true scope of the settlement agreement can be determined only by reference to the context in which it was made. And then they basically, at paragraph 11, recite the fact that they knew about Mr. Grano and that they were, in the middle of that paragraph, it would be very unusual to provide for such an eventuality, i.e. an assignment, in an agreement of this kind, unless perhaps something had happened to raise the possibility of an assignment. However, if that possibility had occurred to Mr. Siddiqui, one would have expected him to have ensured that the agreement provided for it in terms. The fact that it does not do so strongly suggests the party did not envisage it as a possibility. And then last sentence, there's no reason to think that the parties had such an eventuality in mind. they'd thought about it and had intended to provide for it, it's impossible to think that they would have done so in such an unbusinesslike way. And then there was some discussion before the judge about the purpose of including the words "by any person whatsoever" in the context of dealings between the parties. Mr. Miles submitted they were intended to ensure that the agreement extended to claims arising in favour of third parties such as Mr. Grano. I find it difficult to accept that the parties would have dealt with a matter of that importance in such an oblique way. I think the inclusion of those words is also to be explained by the context in which the agreement was made. And the same point is made in paragraphs 13 and 14. And finally, perhaps one can see with a slightly wry smile in paragraph 15, Lord Justice Morbigg says this: "In the end, however much one subjects wording of this kind to textual analysis, question whether the clause was intended to have the effect of extinguishing Mr. Casmany's rights obtained from third parties inevitably elicits a response that is largely intuitive, but which is for that reason no less sound, being based on the nature of the agreement and the context in which it was made." I'm sorry to weary you by taking you almost through the whole of that, but I just wanted to demonstrate that in my submission, is a typical way in which, in the special arena of settlement agreements, the court will have close regard to what the parties either knew or must have intended by reference to context and the surrounding circumstances at the time of entering into the settlement. And this was also emphasised briefly in Ocean Bulk. If we could just go behind tab 27. This was a strikeout decision, went all the way up to the Supreme Court, the decision about admissibility. Basically, it was the question is whether 4 representations that had been made during negotiations, because they were without prejudice, whether they could nevertheless be admitted for the purpose of interpretation. And one can see in the holding on 462, at the same point being made, the interpretation exception sought by the defendant to establish the meaning of the clause in the settlement agreement, ordinary principles governing the interpretation of contracts which require the court, when construing the contractual language used by the parties, to consider the factual matrix and the surrounding circumstances, so as to make an objective assessment of their intentions. It applied to a settlement agreement whether or not the negotiations leading to it had been without prejudice, an approach which both accorded with the underlying purpose of the without prejudice rule, encourage frankness and promote settlement, and also ensuring that the principles of construction of contracts were properly respected. Accordingly, since justice clearly demanded it, the interpretation exception, that's to the without prejudice rule, would be recognised as an exception to the rule, and the without prejudice communications on which the defendant sought to rely were in principle admissible in evidence as part of the factual matrix of the surrounding circumstances and the construction of the agreement and on the issue of estoppel. And if one just delves briefly into the judgments, you'll see at paragraph on page C479, at paragraph 36 onwards, Lord Clark refers first to Lord Stane in Westminster City Council, and Lord Hoffman in Chartbrook, paragraph 37. And then at paragraph 38, not in dispute that when negotiations which culminate in an agreement are not without prejudice, the exclusionary rule applies to the correct approach to the construction of the agreement, nor is it in dispute that in those circumstances evidence of the factual matrix is admissible as an aid to interpretation, even when the evidence formed part of the negotiations. The distinction between objective facts and other statements made in the course of negotiations is clearly stated by Lord Hoffman. And then over the page, paragraph 39, there's the passage which Kim Lewison cites in his book about the fact that trial judges frequently have to find where the line is between the two types of pre-contractual negotiations, those which are admissible and those which are not. And you'll see it finally, paragraph 40, in the middle of the paragraph, Lord Clark says, that background knowledge may well include objective facts communicated by one party to the other in the course of negotiations. The process of interpretation should in principle be the same, whether the negotiations were without prejudice or not. In both cases, the evidence is admitted in order to enable the court to make an objective assessment of the parties' intentions. And it may be worth just, I said finally, but could I just invite you to look at paragraph 44, where the Lordships looked at an article by Sir Richard Buxton, who sought to equate the remedy of rectification with this exercise. And paragraph 45, Lord Clerk said, "I'm not sure that I would put it quite as high as Sir Richard does, but I entirely agree with him that the problems of which both the principles of rectification and the principles of construction, as explained in recent cases, grapple are closely related. It's an important factor in leading to the conclusion that evidence of what was said or written in the course of without prejudice negotiation should in principle be admissible, both when the court is considering a plea of rectification based on an alleged common understanding during the negotiations, and when the court is considering a submission that the factual matrix relevant to the true construction of a settlement agreement includes evidence of an objective fact communicated in the course of such negotiations." And that is also echoed very pithily by Lord Phillips, paragraph 48. "The principle to be deprived from this appeal can be shortly stated. When construing a contract between two parties, evidence of facts within their common knowledge is admissible, where those facts have a bearing on the meaning that should be given to the words of the contract. This is so even where the knowledge of those facts is conveyed by one party to the other in the course of negotiations that are conducted without prejudice. This principle applies both in the case of a contract that results from the without prejudice negotiations and in the case of any other subsequent contract concluded between the same parties." And then finally, as far as the case law is concerned, could I just then take you to, in part 3 of the authorities bundle, that decision that the judge referred to, namely Mr. Justice Jacobs, in the global displays case. And for present purposes, the issue of construction in this case was whether in a settlement agreement which settled all claims, and I'm paraphrasing terribly, relating to orders, also included all claims relating to forecasts. And I don't think we need to know much more than that because the facts in that sense are irrelevant. But certainly there were aspects of the negotiations which were said to have a bearing on that in the ocean bulk sense. And I would like, if I may, just to take you back again to page C861 or paragraph 316. I say back again in the sense that this is the summary of the legal principles that was relied upon by the judge in the court below in our case. And we see them set out here from 316 all the way to the end of 321. They were reproduced in their entirety by the judge. And then there's a discussion. And could I invite your lordships to take it up at paragraph 325. It's C865. And first of all, Mr. Justice Jacobs refers to Foskett, that's the 9th edition, that's the current edition, on compromise, where at 607 and 608, sorry, 607 and 608, this is said, not infrequently the analysis of the appropriate materials will disclose that the parties expressly or by necessary implication compromise certain matters of dispute, but not others. In some cases, it will be clear that certain matters were expressly or by implication not made part of the compromise. There may be cases where, on any objective view, the parties could and should have dealt with the particular matter but neglected to do so. To what extent will it be permitted by the court to litigate that matter on some future occasion? There is at least in principle a distinction between a compromise of a dispute achieved before the commencement of proceedings and one achieved thereafter. In the former situation, unless the court can imply a term the particular matter is compromised, the agreement as construed must stand. will not rewrite the parties' bargain. It may be possible for the agreement to be effective without the matter in question having been embraced within it. And then Mr. Justice Jacobs refers to the fact that an equivalent passage from an earlier edition of Foskett was referred to by this court and approved in Datani. And he then refers at paragraph 327 to paragraphs 603 and 604 of Foskett. And he describes, Mr. Justice Jacobs describes as an important aspect of the whole subject of compromise. It's the need which may arise subsequently to the making of a compromise for a court to identify precisely the disputes which have been settled. To that end, there will be a variety of materials to examine. These include, first and foremost, the agreement itself. As Foskett then notes, an agreement's phraseology may not always yield the answer to the question in hand. As observed previously, in the normal course of events, the parties' negotiations are inadmissible as an aid to construction of an agreement. However, they are relevant and admissible to assist in resolving any ambiguity or phraseology in the agreement or to identify the disputes the parties intended to resolve. It is axiomatic that the analysis of these materials is an objective one, the subjective intentions of each party being irrelevant. An objective analysis of the factual matrix that forms the background to the compromise is required to enable the disputes to be settled. And then, briefly, what Mr. Justice Jacobs then does in this case is first he goes to the words, and you see that in paragraph 328. And he spends right up to, I think it's fair to say, paragraph 348, looking at the words. And in a nutshell, he found that they were clear. He said that, I consider this is the most significant factor in his case in the unitary exercise of construction. The letter agreement is clearly a document drafted with the benefit of legal advice, used terminology and expressions which a commercial lawyer would be familiar: release, waiver, full and final settlement, claims, damages or losses whatsoever, and so forth. It was a fact known to GDS prior to conclusion of the settlement agreement as a result of discussions in New York that NCR was receiving in-house legal advice. Furthermore, apart from NCR's submissions that the failure to refer expressly to forecast was an obvious drafting error, NCR did not identify any other errors or suggest that the letter agreement was, apart from that omission, not well drafted. In these circumstances, and given the identification of the disputes which have been settled, depends first and foremost on the language. I consider this as a case where the agreement can and should be interpreted principally by textual analysis. And then nevertheless, over the page, we see that he goes to the background circumstances and the matrix, as it were. And because he found at paragraph 350 that both parties knew that GDS were making complaints about the falsity of forecasts, he basically said there are a range of issues in play, and if they were wanted to have dealt with those issues, they should have done so. To cut a long story short, he found at 352 that this wasn't a wipe the slate clean sort of agreement, and in the end, he said that the words were so clear, and it wasn't suggested to the contrary, apart from one point in issue, that he didn't need to take that matter any further. The fundamental point being that he cited that approach in Foskett. He followed the approach in Foskett, notwithstanding his views on the clarity of the drafting. He then went to the factual circumstances and indeed looked at the negotiations and found that there was nothing there, in effect, that assisted the party that was trying to prevent the second set of proceedings based on the forecast. Now, whilst on global solutions, display solutions, could I just ask you to note that, for what it's worth, we say that the judge was wrong at paragraph 143 of his judgment, at A189, to conclude that Mr. Justice Jacobs in that case was, quote, able to avoid determining the admissibility of the statements made in negotiations, close quote. In our submission, he plainly did admit them. He just didn't think that in the unitary exercise they carried any weight. One last line of cases, which I hope to take quickly, and this is only by analogy. There is a line of settlement cases, that is to say, cases which concern the construction of a settlement agreement and the ability of a person subsequently to bring separate proceedings, which create special problems due to the complex nature of causes of action themselves. And these cases are where a third party attempts to rely on earlier settlement agreements of which they were not a party. And if I could just ask you to look briefly, I think it's at tab 22, at Heaton. Which concerned, again, another case that went all the way up to this time the House of Lords, concerned a settlement agreement and its construction. And the question was whether a non-party to the agreement could bring up a subsequent claim, and in turn whether the full and final settlement of the first claim against the first defendant extinguished the claim of the second in the second proceedings. And for present purposes, in paragraph 9, we see that in those circumstances, Lord Bingham confirmed that that issue turned on the terms of the settlement agreement between A and B, which must be the primary focus of attention, and the agreement must be construed in its appropriate factual context. Nevertheless, when determining the effect of the agreement, you will see that in paragraph 5 of his judgment, and this is explained in the later case of McGill by Lord Justice Henderson, Lord Bingham refers, especially in the second half of the judgment, of the paragraph 5, to the subjective motivations of the claimant in the first proceedings. A may agree to settle with B for X pounds, not because either party regards the sum as the full measure of A's loss, but for many other reasons. It may be known that B is uninsured, X represents the limit of his ability to pay, or A may wish to pocket a small sum in order to finance litigation against other parties. It may be that A is old and ill and prefers to accept a small sum now rather than a larger sum years later. Or it may be that there is a contractual or other limitation on B's liability to A. But it's just that A should be precluded from recovering substantial damages against C in a case where he has accepted the sum representing the full measure of his estimated loss. It is unjust that A should be so precluded where he has not. And it's interesting, before we leave Heaton and see how it was explained in McGill, so sub-paragraph 5 in paragraph 9, C321, Lord Bingham identified the alternative means by which one normally protects against contribution claims. If B, on compromising A's claim, wishes to protect himself against any claim against him by C claiming contribution, he may achieve that end either by obtaining an enforceable undertaking by A not to pursue any claim against C relating to the subject matter of the compromise, or B, by obtaining an indemnity from A against any liability to which B may become subject relating to the subject matter of the compromise. I think in the next and final bundle 3, or file 3 of the authorities, I think it's the first tab. Sorry, I've got mine in a slightly different order. Yes, tab 36. This is the last authority I want to show you. In McGill, decision of this court, this was a case where a footballer sued one football agent and then sued a second football agent, and the question again was whether he was entitled to do so, having settled against the first football agent. And if we pick up Lord Justice Henderson's judgment, he, first of all, cites paragraph 87, paragraph 5 of Lord Bingham, that we just looked at in Heaton. And then he cites paragraph 8, paragraph 88, again we looked at that. And 89, paragraph 9, primary focus of attention must be to construe the agreement in its appropriate factual context. And jumping then, if I may, to paragraph 100 on page C661, Lord Justice Henderson said, it's harder to know what weight, if any, the court should attach to the judge's finding at paragraph 127 that Mr. McGill, the football player, saw the real perpetrators as SEM and Bolton, the second defendant in the second proceedings, and agreed to take $50,000 to leave the player alone. On the one hand, subjective considerations of this nature would not fit easily with the essentially objective nature of the questions posed by Jameson and Heaton. On the other hand, the motivation of a claimant in agreeing to accept a sum by way of compromise representing less than the full measure of his estimated loss was clearly regarded as relevant by Lord Bingham in Heaton. In my judgment, fairness requires the court should be able to take such motivation into account as part of the factual matrix relevant to the issues, whether the claimant has indeed accepted a sum representing the full measure of the estimated loss. The tension between a purely objective approach to this question and subjective considerations of the kind mentioned by Lord Bingham may perhaps be rationalised by saying that the court cannot sensibly form a view on the question whether the sum accepted in compromise represented the full measure of the claimant's loss without knowing what it was the claimant wished to achieve by entering into the compromise. Now, as I say, I go to this line of cases simply to emphasise that these cases are concerned with the construction of settlement agreements at the behest of third parties after the event, and they are concerned to work out the full nature and extent of the settlement agreement. And the courts have confirmed that the purely objective approach is not the only approach, and that it's plain that the unusual nature of both causes of action and settlement agreements are such that the factual circumstances can be not quite the same in terms of admissibility as in an ordinary commercial contract. Now, it's right to say that in our case, the judge found simply as inadmissible the entirety of Mr. Schofield's evidence for the purposes of interpretation. And we see that at paragraph 133 of his judgment, behind tab 12. At page 187. First of all, paragraph 133, he simply said it falls foul of the basic rule that evidence of previous negotiations and expressions of subjective intention are not admissible. So evidence of previous negotiations and expressions of subjective intention are not admissible. And then at paragraph 141, last sentence, he also found it was not admissible because the settlement agreement allows of no ambiguity. And finally, at 136, I think it's fair to say that if I'm wrong about admissibility, it's not strong compared to the clear wording of the settlement agreement, and so he again didn't have regard to it on that basis either. So we say that this case presents similar issues to some of the issues we've seen in the authorities. The settlement agreement can only properly be assessed in the context of the known facts. And we've summarised the relevant known facts for these purposes, paragraph 5 of our supplemental skeleton argument. And it may be just worth looking at that quickly now, my lords. I'm not sure. I have that now in tab 26. Page, I believe it's 457. This is a summary of what we say relevantly is contained in Mr. Schofield's statement. So, number one, before the Barclays litigation, discussions had taken place between him and representatives of Barclays in which he had complained that the joint administrators had not acted correctly and had caused the settlement companies to incur significant losses. In response, representatives of Barclays had told him that such complaints were absolutely not for Barclays to deal with, and that he should instead take action against the JAs and their advisors. The settlement companies, secondly, made no claims against the JAs in the Barclays litigation, but they were expressly reserved in the pleading itself, and you have the reference. And then at the mediation, Barclays adopted the same position regarding complaints or claims against the JAs that it had previously done in discussions with Mr. Schofield. Namely, that they were not there to negotiate any claims the settlement companies might have against the JAs or their advisors. Now,
just pausing there, we saw in the authorities that what could be admissible was objective facts communicated in the course of negotiations. So, which of these do you say are objective facts?
Well, the facts. Yes. Everything apart from C in this summary is not in negotiations at all. So the negotiations could only really have taken place at the mediation itself on the 30th of November 2015. So there's a long history of this discussion where the bank knows that there's lurking...
I don't quite understand that answer. I'm sorry to interrupt you. But why is not A part of negotiations? It's not part of the mediation, to be sure.
Yes.
So it's not the immediate predecessor negotiation to the settlement agreement. But nevertheless, this is discussions between the parties in which, to put it neutrally, complaints are raised and responses given. Why is that not part of the negotiating process?
Because at that stage there was no question of negotiating a settlement at all on the evidence. This was long before. These were not without prejudice or open negotiations of any nature. They were meetings that Mr. Schofield had with the bank, at which he was making these complaints. But there was no question of trying to reach a settlement of any nature.
All right.
So it's a sort of long history of discussions, which is somewhat monothematic, in the sense that he was saying, I want to make a claim against them, and the bank was saying, well, that's not a matter for us, you have to take a claim against them. And that was something he says that was repeated in the mediation.
I understand your submission on that. Let's then look at B, which undoubtedly is an objective fact, known to both parties, because it's a simple statement of what claims were and were not made in the Barclays litigation. And as is correctly recorded there was an express reservation by the companies of their rights to make claims against the joint administrations in the Barclays litigation. Now, why is that not a point against your interpretation of the settlement agreement? Because whereas in the litigation there was an express reservation of such rights, in the settlement agreement there is no such express reservation of such rights.
Yes. The reason, first of all, that one alights upon B is because it's entirely consistent with A. In other words, both parties knew that he was contemplating these claims against Barclays, and therefore, when he was repeatedly told, well, that's a matter for you, you must plough your own furrow on that, that is relevant to seeing what they intended when they actually entered into the settlement agreement. Now,
I mean, that sounds like what they subjectively intended. That doesn't sound like an objective fact. That sounds like what they subjectively intended.
Well, what the knowledge is that he has repeatedly said, I've got this claim that I want to take against. That's a fact. There's a claim, he wants to take it. On the bank's side, they are saying, well, that's not a matter for us. That's not something we're, by the time of the mediation, negotiating. That's a matter for you.
That's what they're saying. But there's an objective fact here, surely, which is that Mr. Schofield is complaining to Barclays about their relationship with the joint administrator.
Yes.
And they're saying, well, that's not a complaint you should make to us.
Yes.
So if that's not ruled out as intention, that seems to be unhelpful to your construction argument, because they've got a reason to get rid of that threat.
Well, except, of course, by the time you get to the negotiations, they're saying it again.
Well, they would say that, wouldn't they? I mean, they're not going to concede the claim. Their stance is, you take that up with the administrators, but there's still a complaint being made to them by Mr. Schofield about Barclays.
Yes, but what our point is, our purpose for relying on intention of the parties is not to construe the very words that were used in the instrument. It is in order to understand what they must have intended by the instrument. It's not the same thing. So if it is known as a fact in the world between them that that's what Mr. Schofield is going to do, and he's been told that that's a matter for him and he must go off and do it if that's what he wants to do, that's relevant when working out what the settlement agreement means. Which is not the same as saying, my understanding of what this word means or this phrase means is as follows. That's subjective intention by reference to the drafting and so forth. None of this is about the drafting exercise at all. It's about working out, going back to Foskett's book and Mr. Justice Jacob, what in a sense, what garden they were standing in. Which were they standing in the garden which included the administrator's claims, or were they standing in a different garden, which is where we would suggest objectively they thought they were standing, which carved out the administrator's claims. That wasn't within the scope of the dispute that they were settling.
Can I just try breaking it down? In terms of what Mr. Schofield had said to the bank, or indeed in his pleadings, it was apparent that he had in mind the possibility of a claim against some people other than Barclays. Of itself, that must be against you, because that suggests that the parties would have had in contemplation at the time of the settlement agreement the possibility of claims against other people, not just this dispute. So your argument turns, does it, on what the bank's response is?
Yeah, yes, it's looked at together, but I can't look at the first part without the second part. By the time you get to a mediation, there's a history of this same monothematic discussion. And when you get there, Mr. Schofield starts again to refer to his claims against the administrators. And the bank says, well, no, we're not going there. That's nothing to do with us. That's a matter for you hereafter. And that, we say, does engage what Mr. Foskett refers to in his book, and also what Mr. Justice Jacobs accepted in Global Solutions, Global Displays.
So just to be clear, in terms of what the bank says, what is the objective fact being conveyed?
That they are they're not there to negotiate his claim against the administrators, and that is a matter for him thereafter to take up with them. And the important thing is that was simply reconfirming what had been said to him on previous occasions, consistently throughout. And that's relevant because, first, the parties to the settlement agreement are assumed to have behaved honestly and transparently. They knew that there was one and only one identified lurking dispute, a claim by Mr. Schofield against and his companies against the joint administrators and their advisors. And the parties knew that the claims were important and valuable to Mr. Schofield.
It may be my fault, but I didn't quite understand what your answer was to my question about point B, which is the fact, which was an objective fact and which was known to both parties, that the companies in the Barclays litigation had expressly reserved their rights to make claims against the JAs. And why do you say that that is not a point that actively militates against your interpretation of the settlement agreement when one sees that there is no such express reservation in the settlement agreement?
Well, two answers, if I may. The first is, as we have set out in our skeleton argument, the absence of a reservation of right is not something that could be relied upon in these situations. And you get that from various of the authorities. I haven't got the paragraph of our skeleton to hand.
Well, it may not be terribly illuminating in ordinary circumstances that there's no express reservation. But the reason why I'm asking the question is that in the present case, you are saying that there is contextual material which puts a different complexion on the settlement agreement to that which the language of the agreement might lead one to conclude. But a key element of that contextual material might be thought to actually point in the opposite direction.
Yes, we invite the court to look at the contextual material together. In other words, the reservation of the rights simply underlines Mr. Schofield's evidence that he intended to proceed as he had said he would against the administrators. And then, as my Lord Justice Newey observed, the bank's response being that that is a matter for him in due course to take up thereafter. It's all of a one rather than looking at it just on its own. In other words, they did discuss whether this was in scope of the negotiations that led to the settlement agreement. And the reasonable inference is that they considered that it was not as a result of things that were said between them and went across the line. But it is right that in several cases it has been stated and restated that the absence of a reservation in the settlement agreement is not something that should properly be relied on.
Doesn't that depend on the circumstances, as Lord Justice Arnold was suggesting? I mean, perhaps we should look at the key passage to see whether it's susceptible of the interpretation that it depends on the circumstances.
Yes. Yes, thank you. I'm reminded it's in our grounds of appeal at A16. Uh, 1B. So the references are to Heaton, Gladman, and McGill. We've seen Heaton and McGill, starting with Heaton, which is in file 2, behind tab 22, and at paragraph 9, subparagraph 4, Lord Bingham said, whilst an express reservation by A of his right to sue C will fortify the inference that A is not treating the sum recovered from B as representing the full measure of his loss, the absence of such a reservation is of lesser and perhaps of no significance, since there is no need for A to reserve a right to do that which A is, in the ordinary way, fully entitled to do without any such reservation.
Yeah, but this is all in the context of the rule about releases of joint tortfeasors.
It is, but in one sense it's all the more important there. And I think the same point is made by Lord Justice Briggs in the case behind tab 33, Gladman, in this court, where again this court relied again on Lord Bingham in the same context.
So that's paragraph 35, is it?
It is. Tab 33.
Yeah, you need to read what he says after the quote, don't you? Well, he explains why the absence of an express covenant not to sue the respondents is of no significance, because the ordinary effect of a settlement against one or more joint tortfeasors is without more to prohibit any proceedings by the claimant against the others.
Yeah.
I mean, there is also obviously the difference that here we do have an indemnity and an express covenant.
Yes.
I mean, we'll come on to the construction of those, but
yes.
There is that obvious
So
difference.
it's the reverse situation.
It is. What's being said, it's often said, isn't it? Well, why didn't they provide for it expressly? And one answer to that would be because they had decided not to negotiate that at all. That's how it's explained. And that takes us all the way back to Foskett and Mr. Justice Jacobs and Datani in this court. But it is permissible to see what was said about the scope of what it was that they were disputing, which garden they were standing in, to use that probably not terribly apt metaphor. This and that evidence, and we'll go to the agreement in a moment now. That evidence also has a bearing on, as I say, Mr. Schofield's evidence and those circumstances, on what the parties are likely to have intended, both about which affiliates were being released, but also who the affiliates were.
Sorry, what's the distinction?
Well, on the one hand, there's a question of, as an example, the releasing one's own affiliates point. There's also the question of who were the affiliates when you're interpreting what the parties intended in their definition of affiliates. Contextually, one looks to see what we say was agreed to be the scope of the dispute they were settling. And so on that last point, and then we'll go to the agreement, as an example, the joint administrators were known to the bank to be, as it were, Mr. Schofield's sworn enemies. And the bank knew that his complaint was that he had no control over them and that they would, that he wanted to sue them for what they had done. And the question would be, would they really have intended to describe the joint administrators in that context as the claimant's affiliates?
I mean, there's a very good... All you're saying suggests that there was a perfectly good commercial reason for wishing those claims to be covered, because otherwise it was foreseeable that Mr. Schofield would cause claims to be brought against those people. And those people might well bring in Barclays as co-contributors.
Yes, but as we know, the settlement agreement actually catered for that in its express terms.
So do you accept that you covenanted not to bring proceedings against the joint administrators?
My lord, no, because we don't accept that they're affiliates.
No, well, that's the point in a way. I mean, you don't accept that you covenanted not to bring proceedings against the joint administrators. And you don't accept, as I understand it, that you agreed to indemnify the bank in the event that proceedings were brought against the joint administrators. So in other words, on your case, there was no protection for the bank if claims were brought against the joint administrators, as Mr. Schofield had indicated he had in mind to do.
Well, no, the affiliates of the companies may not sue the bank under the terms of the agreement.
Well, there was no question of the joint administrators being barred from suing the bank. The question is whether you had undertaken not to sue the joint administrators. There was no protection for the bank in relation to claims you might bring against the joint administrators unless it comes from the clauses that are in issue. I think you say, well, the bank was adequately protected against contribution claims because of the terms of clause 3. But on your construction, those didn't bite. Those didn't help the bank.
That's if your lordships are against us on who the affiliates are. So our case is that the joint administrators are not affiliates from the meaning of this.
No, quite. But that means the bank got no protection.
And absolutely, on that basis.
So although it was known that you had in contemplation claims against the joint administrators, and although, as we've seen, it's commonly thought that those settling proceedings might wish to protect themselves against ricochet claims by covenants and indemnities. Here, on your case, the bank did not do so.
That's absolutely right, my lord, yes.
Yeah.
And that's because of what has gone between the parties.
Meaning, why wouldn't the bank wish to protect itself against such claims?
Well, it is the bank had, knowing that the claims were in the offing, the bank had told Mr. Schofield that they were not negotiating those claims, and it was a matter for him thereafter to pursue them.
So they knowingly left themselves open to future claims by the joint administrators, should you bring claims against the joint administrators?
Yes.
It seems very improbable.
Well, except that is, in fact, the basis on which we say they were negotiating with us. But that's on the basis that they're not affiliates. If they are affiliates...
But it all comes to the same thing. Whether or not they're affiliates, whichever route to your case you go down, you end up with no protection for the bank, don't you?
My lord, no. If they're affiliates, the bank is protected.
So can we just... Sorry, I'm taking you out of your course.
Yes.
So if we take 3.2, each party, well, that obviously covers you, agrees that it will not bring any proceedings against any released party. So on this hypothesis, the joint administrators are affiliates. Are you undertaking not to bring proceedings against them?
Well, look, each party agrees it will not bring any proceedings against any other released party, it must be.
So I follow. So the joint administrators are within the definition of released parties, but they don't count because they're not other released parties. So
Yes.
You're not covenanting not to bring proceedings against the joint administrators. And whichever route your outcome you take, you end up with the fact that there is no protection for the bank.
Well, my lord, there is, because in the second sentence of 3.2, take all necessary steps, if necessary, by the payment of money to ensure that none of the affiliates brings any proceedings. And then in 3.4, there's an indemnity.
Are you indemnifying the bank against any claim you might bring against the joint administrators?
No, we're indemnifying the bank against any claim that the administrators on this footing might bring against the bank.
Including a contribution claim?
Yes.
So let me just get that clear. So clause 3.4 on your case.
Well, no, this is not on my case. This is on if I lose on the affiliate issue.
But can I just be clear? Assume that, for the sake of argument, that the administrators count as affiliates. Then in that case, clause 3.4 provides for you to indemnify the bank
Yes.
against any contribution claim brought by the joint administrators or Clyde Co.
If they're affiliates, yes.
Yeah. And if they're not affiliates, then the bank is entirely unprotected in relation to claims
Yes.
you might bring against.
Yes.
Can we just look at 3.4 one moment? So 3.4, supposing that the joint administrators are affiliates, then it bites because if contrary to clause point 2, would it be contrary to clause 3.2? On your case, it wouldn't, would it? Because you say, well, you're free.
It's the second sentence, my lord, I think.
I see. Okay, so you're covenanting to ensure that none of your affiliates. Are you an affiliate?
My lord, meaning...
Are the claimants or applicants in these proceedings affiliates, or are they just parties?
Well, they are affiliates of each other.
Okay, so you've covenanted that you will take all steps to ensure that none of you will bring proceedings against the joint administrators on this hypothesis. Otherwise, clause 3.4 doesn't bite. So why do we need to get to 3.4? Because on this hypothesis, 3.2 means you've covenanted to ensure that you won't bring any proceedings against the joint administrators.
Well, my lord, 3.2, each party agrees it will not bring any proceedings against, and it obviously doesn't mean any released party. It has to mean any other released party.
Well,
And-
here we're concerned with the second sentence, I thought you said. So it's again any other released party, is it?
Yes.
Okay, so...
I'm so sorry, no. Each party will take all necessary steps to ensure that none of its affiliates brings any proceedings or asserts a claim against any other released party. Yes, sorry.
So we're not in 3.4 at all, because there's been no breach of clause 3.2.
Well, my lord, that depends on the premise.
Well, as I understood it, your premise was there was no breach of clause 3.2.
No, I meant the factual premise. Who's suing? So if I am suing the joint administrators, and if joint administrators then seek to make a contribution claim against Barclays, then I'm to take all steps necessary to ensure that none of the affiliates, including obviously the JAs, bring those proceedings. And if I'm in breach of that, then you drop down to 3.4.
Well, all right then. Let's suppose that you've undertaken to take all steps necessary to ensure that the joint administrators don't bring any claims against Barclays.
Yes.
Well, how do you achieve that except by not bringing your claims?
Well, of course, until you bring a claim, you can't possibly know whether there's any question of contribution involved.
Yeah.
And indeed, there's still, even to date, has not been a claim asserted against Barclays, even in these proceedings, by the JAs or Clyde Co.
And if they did assert a claim, would you then be obliged to discontinue your proceedings to stop those claims being pursued?
Well, first of all, we cannot stop them doing it, obviously, but if it becomes clear that the contribution claim is to be made, then we could deduct from the compensation that is payable to us such sum as would be equivalent to the amount that they would be entitled to against Barclays. That would be the equivalent of the words by the payment of money.
But those words are without limitation.
Yes,
You can't get away with not doing anything else just by paying money.
but it doesn't. There's no obvious other way that you can do that, which is why we have clause 3.4. If contrary to clause 3.2 above, they nevertheless continue, and hence you get the indemnity. So the premise is that you don't manage to take those necessary steps once they've made that claim, and so they catch you under 3.4 because you're then giving the indemnity. And this is how the parties addressed ricochet claims. None of this would make any sense at all if we had released the joint administrators or Clyde Co as our own affiliates, as alleged. It's just not what we say the parties to the settlement agreement were doing. They were addressing the question of ricochet claims or contribution claims in the conventional manner. So the premise of 3.4 is that you've not succeeded in your obligations in 3.2, and you're now having to indemnify the bank in this example in respect of whether it's damages, costs, and so forth.
I mean, suppose that, well, this may be more or less what we're dealing with. Well, I don't know. So suppose that the proceedings go on, the joint administrators bring a contribution claim against Barclays. Barclays say to you, look, you've got to ensure that there are no proceedings against us. I mean, you've got no answer to that, have you?
Which is why we are then faced with the indemnity in 3.4.
But why can't they just enforce 3.2 and say, you've got to stop it?
But we can't.
Well, you can very easily by discontinuing the proceedings.
But that doesn't stop necessarily the claims or claims being made against Barclays, because it can be any form of claim.
Well,
It's got to be a contribution claim. It's a very, very wide-ranging claims, and all that's being said is that it's recognised, the draftsman recognised that 3.2 second sentence is by no means perfect and can't necessarily be policed or enforced, which is why they conventionally, I would suggest, in 3.4 have the customary indemnity.
Yeah.
Which is what Lord Bingham, I think, was referring to in Heaton as the way in which one would cater for these sorts of claims in a settlement agreement. What we say about this agreement, as you know, is that starting with 2.1, we say that the somewhat crucial point about affiliates and asking oneself what does 2.1 mean in terms of who has been who is settling what. The key to the interpretation is to treat an affiliate as belonging to a party. I suppose that's what affiliation means. And that the possessive there, T-H-E-I-R, in the definition, that shows that that's what the parties intended. So if we go back to the definition of released parties, it's the parties and their affiliates. So that we say that on each occasion when in this agreement the term released party or released parties appears, it is appropriate and the right approach simply to insert that definition.
Can we just test that? 3.1.
3.1.
3.1.
Yes.
Each party agrees that the released parties are released. So when we come to agrees that the released parties the released parties is the parties and their affiliates. And we see what affiliates means. So if we insert in place of the released parties,
Yes.
we get the parties and their subsidiaries, parents, employees, and so on.
Yes.
And that's much too wide for your purposes, isn't it?
Well, may I just remind you that the judge and I think even the parties on this appeal, I'm not sure about the joint administrators, accept that the word other should appear before released parties, because the first party referred to, the each party, is itself a released party.
Where does the judge accept that?
Paragraph 118 at A182.
So he puts it both ways.
And it's obviously not intended to cover the party in the phrase each party, because he wouldn't be agreeing to release himself and discharge himself and so forth, or itself.
Well, there's no harm in it.
Well, it's not legally possible, I don't think.
No, but there's no harm in it. I mean, if I
It's not
agree
likely
to release myself, well, fine.
It's not likely the parties would do that, or say that.
Well, but is that correct? Suppose that the party's intention is to use the most inclusive language possible. They want to include all possibilities, the outer limits of the universe, the multiverse. That includes suing yourself, even though actually it's legally impossible.
Yeah,
What's the problem with that?
Well, it's just not something that the court would countenance as likely to be included. It's not legally possible. It's not just a pleonasm. It's positively a concept not known to the law. And we say it's explicable, because if one simply reads, each party agrees that the parties and their affiliate, the other parties and their affiliates, are released, that would make sense.
So would inserting the word other before release, would it?
Yes, so it would read, each party agrees that the other parties and their affiliates are
But
released.
if you just insert other, you get each party agrees that the other released party.
But I am, for released parties, I am reading the definition, the parties and their affiliates.
But you say, well, it can't make sense for A to agree to release A.
Yes.
Well, that's solved simply by assuming that they mean the other released parties.
Yes, but the definition of released parties is the parties and their affiliates. And the draftsmen, we would say correctly, have joined affiliates to parties in the possessive sense. That that is the normal way of doing it, we would say. You don't release your own affiliates. You release it's the other party's affiliates that you're concerned about. Across the line. You're not really interested in releasing your own affiliates. It's what the other side's affiliates, and that's why the definition is the parties and their affiliates, not the affiliates. And without trespassing on the debate about who the affiliates are, that does make sense in that, in broad terms, the affiliates are, as we submitted to the judge, those people who are, as it were, in your camp, the directors and employees and parents and subsidiaries and so forth. And the same applies to Barclays and its affiliates. And so on each occasion, we say, when the word released party appears in this agreement, one can read the definition in the parties and their affiliates. And that makes perfect sense, subject only to adding in the word other in the way that the judge also accepted was appropriate.
Can we just think about that? Suppose that the word affiliates extends to the administrators as officers and agents. Plainly, they would be affiliates of your parties, not Barclays. So why would it make sense then to exclude them from the release? I mean, you say, well, it makes sense to not release the people in your camp, but you just, I think, explained that the joint administrators weren't in your camp.
Yes,
So
that is our primary case.
Yeah.
Our primary cases, our secondary cases, if they were in our camp, nevertheless, the parties to this agreement did not intend to for each party to release its own affiliates.
But when you say, well, it can be assumed that the affiliates are in your camp and therefore you're not going to want to bring claims against them. Well, it's not true here, is it? The people who could be affiliates of you were definitely people you might want to bring claims against.
No, it's more that we would not want to release claims against, say, employees and so forth. That's more the point. Any more than Barclays would want to release claims that it had regulatory claims internally, disciplinary claims against its employees. An example we give is if the Barclays, after the end of the litigation, wanted to discipline one of its employees for the mis-selling of the swaps, according to this, they've released that claim. And we say that's just not realistic.
Yeah.
And if one studies Barclays' position, I think one's entitled to, we're entitled to say that it is very difficult to imagine that the parties intended to stop Barclays from doing all the things that we've listed in our skeleton argument, all of which would be caught in respect of its own employees, parents, subsidiaries, and so forth, if my learned friends are right. And we say that these considerations militate against the idea that the parties were releasing their own affiliates. Including apparently all their own legal advisors and so forth. And so we do say that you graft in the definition. And the moment you do that, if you take 2.1, we say that works to show that people who are being released are not one's own affiliates. They're the other parties and or the other parties and their affiliates.
Can I just ask, would you accept that 2.1 and 3.1 would be expected to marry up?
Yes.
Yeah.
And that's because we say that 3.1 also should be construed as reading, each party agrees that the other parties and their affiliates are released and forever discharged from all claims. Again, using the definition. And we do say that there is a looseness of language here, which plainly wasn't thought through if my learned friends were correct. It's particularly acute in clause 3.4. When read in conjunction with clause 1.3. And once one accepts that the settlement companies, REL, REPL and Askwith, are jointly and severally liable to Barclays in respect of all their obligations under this agreement, one can see that 3.4 creates potentially circular liabilities, and also only properly operates, and only really sensibly operate on the basis that there were two camps. On the one hand, the parties referred to in 1.3, and on the other hand, Barclays. And we address that in our respondents' replacement skeleton argument behind tab 9 in the bundle. I'm so sorry. I'm so sorry. That's the wrong one. It's behind tab 26, I believe. No, I was right the first time. Yes, it's paragraph. I'm so sorry. It's A138, paragraph 8. A138, paragraph 8. We say if the three settlement companies would be jointly liable to the other two, the breach of obligations are allegedly owed to each other under the settlement agreement, this would create circular liabilities. Each of them would be liable to the other under the 78 Act as persons liable in respect of the same damage. And the concept that each of the settlement companies is mutually liable to the other for the claims that they have under the settlement agreement against each other or against their respective affiliates isn't coherent or a likely intention of the parties. And we give an example. In the proceedings against them, the joint administrators have claimed that Clyde Co were instructed to give advice to the companies and advice to the joint administrators personally. In that place, it's applying the construction of the Clyde Co. If the joint administrators sued Clyde Co for negligent advice given to them personally, settlement companies would be jointly and severally liable to indemnify Clyde Co by operation of clauses 1.3 and 3.4. One can think of many examples where, because the parties regarded on the one hand REPL, REL and Askwith as jointly obliged to Barclays under this agreement, on the other hand in 3.4, that clause can only properly work on the basis that parties were regarding them as two camps, the claimants in the litigation and the defendants in the litigation, which is the conventional way that one would expect. Otherwise, obviously, you have some impossibilities as a result of the way in which clause 3.4 was drafted. And the clause 1.3 is an important provision, and it does demonstrate the intention of the parties to regard three companies on the one hand as the counterparty to Barclays on the other, reflecting the position in the underlying litigation that was being settled. And as I have submitted, 3.4 can't really be construed in any other way. The same applies later on in the agreement. If one turns to clause 7.2, again, the parties cannot really have intended here anything other than a two-camp scenario. Each party represents and warrants that it's conducted such inquiries and taken such advice as it considers necessary in order to enter into this agreement. In doing so, not relied on anything said or done, or not said or not done by or on behalf of any released party, except to the extent that it is set out expressly in this agreement. In particular, each party acknowledges and agrees that it is not induced to enter into this agreement by any representation or statement made by any released party. This is not relied on any such representation or statement. Each party also accepts that the other parties or their affiliates may have information relevant to the claims or in this agreement. This is not disclosed, and that neither the existence of such information nor any statement or representation made by a released party gives any grounds to vitiate this agreement, to claim damages or to seek any other relief. And we say that that's really only workable conceptually on the basis that you have the one party, which is the claimant companies with their one firm of solicitors and one owner and controller on the one side, and Barclays on the other. It otherwise makes no sense. The same applies at clause 9.5. Each party warrants to the other parties, as at the date of this agreement, no proceedings arising out of a connection with any claims have been commenced or pending, or to the best of its knowledge, or contemplated against any of the released parties. First, obviously, that can't be read literally. But secondly, that's obviously counterfactual. Both parties knew that the claim was to be made against the JAs, or was contemplated, and suggests that the parties were not thinking of own affiliates in that context. And so our overall submission on the release aspect of the dispute is that the parties did not intend to release their own affiliates under this agreement, and that is clear either by going down the two-camp route, which would explain clauses 1.3 and 3.4 in particular, which are the ones that matter, or on the four-party route. We say that all one needs to do is to read in the definition of released party whenever that term appears, so that the words the parties and their affiliates, or the party and its affiliates, are read into the text in the usual way of the definition, and subject only to the insertion of the word other before that to recognise that it can't, in each case, also include the other party referred to. Then the agreement works, and it works to demonstrate that own affiliates were not released and not intended to be released. on that, I think we are entitled to say that it is highly unusual, and we have not found a precedent of any form or nature or any judgment in which a party releases its own affiliates for the purpose of stopping contribution claims. And nor have we found a suggestion, whether it's in Lord Bingham and Heaton or in the subsequent cases, that that's a recognised means of doing so. It doesn't mean, of course, that it can't be done. It's simply that we are entitled to submit that it is unusual to attempt to do that in agreement of this nature. And we say that once one looks at the width of the claims and liabilities which come with the release, they are almost absurdly wide and would impinge on the parties' abilities to make all sorts of non-legal, non-litigation demands and claims against their own people, be they employees, directors or otherwise, including even intercompany claims for accounting and so forth. And that the parties cannot have intended, by using those wide claims, the wide definitions of claims and liability, to release all such claims as between a party and its affiliates. And our case is that they didn't need to, because they had their own way of dealing with ricochet claims, which is the way which Lord Bingham and subsequent cases have recognised as the conventional way. Turning then to the question of who are the affiliates, and the definition of affiliates here, we do submit as a starting point that if I can just describe it as the evidence of Mr. Schofield is admissible and should be admitted to determine who the parties can reasonably have intended should be included in the definition of affiliates.
So on that, you've addressed us on the position at common law. In the skeleton argument, the question was raised about the entire agreement clause, and you've addressed that. That's clause 7.1. What about clause 5.1, second sentence? Neither this agreement nor any related negotiations shall be offered or received in evidence except for the purpose of enforcing this agreement. You, of course, are not enforcing the agreement.
Well, except for the purposes of, we are in the sense that we're relying on them in response to enforcing the enforcement of the agreement. It's all part of the enforcement process. So the court
enforcing the agreement.
No, not all I'm saying is that my only friends are seeking to enforce the agreement, and we are responding. And as part of the overall exercise, we are referring to the matrix of fact in order to interpret the agreement.
So you say you're within the exception?
We do, because that second sentence does not preclude the court from undertaking the normal process of interpretation. Which I think is the effect of the jurisprudence on the entire agreement clause as well. Turning then to the definition of affiliate, and as you will have seen, we we first go to the word as defined on page A446 in the interpretation clause 1.1, second entry. In relation to any person, a subsidiary of that person, a parent of that person, any other subsidiary of that parent, as an employee of that person, of its subsidiaries and of its parents. So starting there, obviously one would not naturally refer to either Clyde Co or the joint administrators as any of those things before going to any of the definitions. And that's because you would not naturally refer to them as affiliates in the ordinary sense of that word. But
well,
of course,
I quite see why you might not refer to them as subsidiaries, parents, or employees, but I think you would refer to at least the joint administrators as affiliates. I mean, if you take the people who are charged with running the companies, are they not naturally to be seen as affiliates?
well, they're court imposed, aren't they? And they're very much there in a different capacity from all the others, because they are there to carry out a statutory scheme, effectively embodied in Schedule B1, which is a very much supplanting management and carrying out, in effect, a statutory exercise. I
mean, they supplant the management by the directors, but actually their duties wouldn't be so different in principle from the duties of directors in the situation. The directors would have to look to the interests of creditors. The administrators have to look to the interests of creditors. These are the people who, as you say, by statute and by appointment, are put in charge of the management of these companies. They fall naturally, surely, within the definition of affiliates if you don't look on to what's then said.
Well, the difficulty I would have with that is that the paragraph 3 statutory purpose is mandatory. And it's difficult to think of these as administrators in that context, or a liquidator for that matter, but certainly administrators, as being an affiliate of the company. It's imposed on the company, as it were, by creditors usually. But more importantly, they come with a sort of statutory imperative to carry out a statutory purpose, which is a straight and narrow gate.
I mean, you accept, well, I think you argue, that they were fiduciaries to you. You say the companies were principals in relation to fiduciary duties owed by the joint administrators.
In one aspect, yes.
So you were the principals with them as the fiduciaries. I mean, that sounds a pretty close relationship.
But that's true of any, that's true of a selling agent. But they wouldn't, a selling agent, in our submission, wouldn't be an affiliate, but would certainly own a fiduciary duty, because he'd be holding the property as a... I mean, you can have all sorts of fiduciary relationships which are not affiliate, are not those of an affiliate.
Yeah.
And then looking at employee, we've got former, present or future, and then directors, officers, employees, shareholders and agents. And the point we have been making in relation first to Clyde Co, well, you've got our written submissions on this. I'm not going to read them out, obviously. But paragraphs 46 through to 48, which I'll just turn to in a moment. As far as they are concerned, we are saying that that is an extremely oblique way of including legal advisors into the definition of affiliates, which again we say would not be a normal way of describing the position, people in the position of Clyde Co, who were the solicitors employed by the administrators, payable out of the estate. we do say that there is a genus here. I never know. Some people say genus, some people say genus. I'm not sure. I'll say genus for the road. But there is a genus here. And when looking at, first of all, you look at the affiliates, the definition of affiliates. When looking at that, you see that these are all persons, as it were, in the family, and including an employee over whom the company has control. And then people who've been on the inside of the tent, as it were. And then when you come to employee, the way in which one construes employee must start by seeing that it forms part of the definition of affiliate. And then you see a long list of people. And forget officers and JAs just for a moment. We say that that list there cannot extend to Clyde Co. And that's underlined by the fact that actually in this agreement, in the places that we have mentioned in our submissions, this is paragraph 48, D to F, legal advisors are referred to separately and discreetly within the settlement agreement itself, in circumstances which were unnecessary if the parties thought that they were within the definition of employee. But most importantly, the starting point, that the intuition, if I can borrow from Lord Justice Moore-Bick's judgment at the end there in Gethsemane, the intuition is that solicitors are not affiliates. They're Clyde Co in this case were not under their control, they were not instructed even in the Barclays litigation. And it's an incredibly oblique way of referring to them, tucked away in the last two words of the definition of employee. If that's what the parties intended, they would have referred to them expressly, either as including legal advisors or in some other way, so that everybody knew what was meant by affiliate, and that it extended all the way to firms of solicitors and other professionals, presumably. But we also say that in relation to the JAs, the joint administrators, former joint administrators, and our case here is paragraphs 49 to 57 of our skeleton, of our main skeleton. We say that given that the parties knew objectively that claim against the JAs was lurking, and given that they knew that that claim was including a claim against the advisors, was the only identified claim by the time of the settlement agreement of this nature, it very much, as Lord Justice Moore-Bick said in Gethsemane, it's an incredibly oblique way of bringing in those claims and getting them covered by this agreement by using the words, by using a definition, employee.
I'm struggling to understand that submission, because, of course, you make your submission, you've addressed us on already about the two camps' interpretation as to the scope of the releases. But if you're wrong about that, one simply approaches this on the basis of we have a defined term, employee, which includes officers and agents, and why on earth is a joint administrator not both an officer and an agent of the company?
Well, in some respects, of course, he's not either. in some respects, because he's slightly sui generis as a person. And even in the statute, for some respects, he is an officer, in some respects, he is not an officer. We know that he doesn't, he's very different from the other people mentioned, from the former present or future directors, officers, properly so-called, employees and shareholders and so forth. This person is quite special and is first and foremost, of course, an officer of the court who comes in to carry out the statutory purpose. And it's just a very strange place to put him in the definition of employee, when the parties know that that claim is something that Mr. Schofield does, through his companies, want to pursue. So from the bank's point of view, if they really thought that they wanted to cover the JAs, they knew how to describe them, how to refer to them, and to make it plain that that's what they wanted to do. They wanted to categorize the joint administrators as affiliates for the purposes of obtaining the releases and or protection against the contribution claims, when in fact they did nothing of the sort and relied on this sub-definition away from affiliate into the definition of employee without either naming them or making it clear that that's what they were doing. And we just say that's not likely, given that they were the only candidate throughout the history.
Well, can I go back to your submission on genus? You said there's no discernible genus, I think at least in relation to the definition of affiliate. But if one looks at the definition of employee, directors, officers, employees, shareholders, agents, the genus there might be suggested is those who act in any broad sense on behalf of the company. And why is not an administrator, by statute, someone who acts on behalf of the company?
Well, he does act on behalf of the company at times when he's performing his functions and is a statutory agent. But the question really is whether this is intended to cover such a statutory agent, such an unusual animal. And we know that he's not, contrary to what my Lord Justice Newey suggested, I would very respectfully suggest that one wouldn't naturally refer to an administrator as an affiliate of the company. And the reason for that is because he doesn't really belong to the company. He's imposed on the company as a statutory animal carrying out statutory purposes, and he is an officer of the court. But he's just very different. I accept that he is technically acting on behalf of the company. He's just a different species of person.
I mean, in one sense, directors are imposed on the company. They're imposed by shareholders. Here you have somebody imposed by creditors.
But the shareholders are
being insolvent.
But the shareholders are already in the part of the. The context here is that this is a small family company owned and controlled by Mr. Schofield, and he's effectively his affiliates, privies, are all the persons mentioned. And they're the ones who are, as it were, stopped or released or whatever. Whereas we say the administrators are in a fundamentally different camp to that, who are not, that's his complaint in a way, are not susceptible to any form of control or direction, and were not chosen by him, not on his side, not in any way affiliated to their cause.
So to be clear, when you say not under control or whatever, you mean by Mr. Schofield? You mean by the member?
Well, or indeed, by including the companies.
Well, the companies are being run by the administrators. I'm not in the interest of the creditors, who are the people who at the time would have seemed to be the only people interested in this company. So
well,
I'm not quite sure.
By the time of this agreement, the administrators were out of office and had gone. They were no longer, they were not now agents. And so...
Well, to be sure, that's relevant when we come to the ex parte James points, but why is that relevant here, given that the definition expressly says any former?
It does. No, I was simply answering the question that, and it may be that I misheard. I was wondering whether it was being suggested that this time the administrators were indeed, as it were, not answerable to anyone because they were still in office. They were not. That's all.
No, I mean, I followed that point. That just going back, you're sort of suggesting, well, what's key is that the administrators, when they were in office, weren't answerable to Mr. Schofield. But he was just a member in circumstances where the companies appeared to be insolvent, so the interests of creditors took over. I'm not quite sure why the fact that they weren't answerable, though to some degree they were, I suppose, but they weren't generally answerable to a member who no longer had an interest in the company should be determinative.
Yes, I mean, ultimately, I'm not saying it's determinative. I think it's one of the factors. And what's happening here is that the most wide-ranging described disputes, claims, demands, and so forth are being released in respect of any period, right, going back to the financial crash and so forth, subject only to the limitation period. And one example of that is the fraud that's referred to in the underlying papers. And the point we are making is that whilst one can see how Miss Bellin, as an example, was an employee, that makes perfect sense. It is very different to lump the administrators into that category of affiliate for the purposes of this agreement, when they're not really in the camp, as it were, of the settlement companies. On the contrary, the complaint was the opposite.
I'm just a little bit puzzled by your approach to this, because you keep on stressing the fact that the word on your submission that we're interpreting is the word defined term affiliate. But it's not in dispute. The defined term affiliate includes the defined term employee. And therefore one turns to see what the defined term employee means.
Yes.
And the case against you isn't really based on some loose definition of affiliate. It's based on the meaning that's given to the defined term employee. So why don't we focus upon that?
My lord, yes. And I think the only point I was making is that one starts by recognising that this is an employee who's said to be an affiliate. That's all. That is, I think, probably acceptable context when looking to see what the parties intended when they were defining employee, because they're defining part of the class of affiliates. And in that context, I was suggesting that when you test it, did they intend that each of these persons was an affiliate? And it's not a problem until you come to either Clyde Co or the joint administrators, because in each case, for the reasons we've given, they're of a different category of individual or person. And we say that they can't, if you take Clyde Co, they can't possibly have, in the phrase "and agents," have added to all of these individuals. The whole cast of people. I mean, take Barclays Bank, all of Barclays Bank's agents, globally, I suppose. I mean, it just can't be that broad. All of Barclays Bank's.
In relation to your clients, who do you say would be covered by agents? What sort of person would be covered by agents?
Well, the classic person would be the consultant who's not on PAYE. Classic.
Well, he might not be an agent at all in the strict sense. He might not.
But he might. I mean, I can't. Because he's just a construct. But
I mean, Do you
a
say
full-time company doctor, shall we say. There's someone who comes in, signs a contract as a consultant, and is in the position of an employee, but is, as a matter of tax, is not.
So can I be clear? You're not suggesting that to be an agent, you have to be capable of affecting a change in legal relations, as a strict definition of agent might suggest. It has some broader definition.
Well, no, I would. It's hard to think because there may be many examples, but I would suggest that the definition should be coloured by the words that have gone before, because that is the Guinness argument, that you don't branch out with the word and agents with external agents such as solicitors and others.
So suppose well, I don't know, you employ someone as an independent contractor. Employ is the wrong word. You employ the services of someone as an independent contractor.
Yeah.
That you say is an agent, even though that person may not be capable of affecting the legal relations between the company and any third party. Well,
this is the problem with, an independent contractor who's fixing the wall, as an example, wouldn't be covered by this. Couldn't be. That would be an absurd suggestion that he's one of my affiliates.
Fixing a wall. So you get in a builder, he's not covered.
No, or anyone who supplies under an agency agreement, all sorts of commercial agents. And we say it makes no difference if the suppliers are professional services.
So who is covered?
Well, it's people in the position of those that went before, but who are not. In my mind, it's trying to cover those insiders who are not actually employees, like your consultant, who's there full time, but in fact is not technically an employee. But he's very much in-house, part of the team, and therefore an affiliate.
If we interpret this as meaning those who act on behalf of the company, would you accept that solicitors act on behalf of the company?
Well, my lord, this is paragraph 48A of our skeleton argument. Solicitors who are instructed by administrators are in a rather strange position. They're not solicitors who have a retainer with the company.
Is that right?
Well, in this case, there's a dispute in this case. I think Clyde Co alleged that they were not agents of the company.
Just can we leave this case aside for a moment? You say that when joint administrators take on solicitors,
yes,
they don't have a retainer from the company. Is that actually right?
Well, what happens is that they can't sue the company for their fees. Their right to remuneration is from the estate, and it's dealt with under the insolvency rules, and they are entitled out of the estate to be paid for the work they've done whilst employed by the administrators.
The joint administrators in taking on the solicitors would be acting as agents, wouldn't they?
They would, but it's a strange relationship because, as you see from our skeleton 48A, it's been said that the solicitors look to the assets of the company for payment. The solicitor has no client as such, because the costs are payable out of a fund, namely the assets of the company. And we say that insofar as there is an agency, it's a very peculiar one.
It's undoubtedly different to the normal situation But presumably you're not suggesting that administrators have a retainer with the solicitors. So it's not personal to the administrators, surely.
That's right.
Okay. Presumably you're not suggesting that there is no retainer at all, because how can solicitors act without a retainer? So what's left but a retainer with the company, albeit a special form of retainer under which their remuneration comes out of the estate?
Yes, and it's more confusing by the fact that, as is pleaded in this case, the solicitors can act for the administrators personally, giving them personal advice, and also giving them advice in respect of their functions under the Act and Schedule B1. Insofar as they're doing the latter, they are, in one sense, agents of the company, but it's an unusual relationship. Because again, in that capacity, they can only be carrying out the statutory purpose or helping the administrator to do so.
That would cover most of the ground, wouldn't it?
Well, it might well. It depends on the facts, but yes, it might well.
Yeah.
And we, as you know, in our examples, and we can pick this up by looking at the agreement itself, we suggest that if you start with clause 6 of the settlement agreement on page A450, clause 6.2, this is within the confidentiality clause. All parties shall procure that no employee or advisor, whether expert, legal advisor or otherwise, acts otherwise than in accordance with the obligations set out in this clause. Again, as you are aware, we say that this is the parties indicating that they don't believe and don't intend that legal advisors should be covered by the phrase employee. That is then emphasised again in clause 6.3. Parties agree that they and their employees, agents, experts and advisors shall make no public statement about the action and so forth. And again, we say that is correct, that they were right to put it that way, because the advisors are not employees.
It's a bit of a muddle, this part of the agreement, isn't it? Because clause 6.3 has employees and agents. And we know that agents are within the definition of employees, so that's redundancy. And they're using different techniques in different clauses.
They are,
sub-clauses.
but I accept that you can have two types of agents, as we've mentioned. That you can have an agent which is caught by the employee, but you can have an agent employee definition, but equally you can have another agent who is not. Whereas we say that legal advisors simply are not. And 6.5, again, same point. The parties and their legal advisors agree to return the documents to the party who disclosed them originally. And again, if legal advisors, if Clifford Chance and Collier Bristow were employees, which my own friends would have them be, then here we have the parties to this agreement showing that they know how to define and refer to legal advisors 3 times. And if they had meant such an important category to be included in the term employee, they would certainly have said so. That's the point we're making.
Well, isn't the point that they may only fall within the definition of employee insofar as they act as agents, and being a legal advisor doesn't necessarily involve acting as an agent. It may do, it may not.
That's the point that the judge
That's the
took.
judge's point, of course.
And that's the point which is the subject of...
That would be some sort of explanation of using both the defined term employee and including references to legal advisors.
Up to a point, but I'm not sure it goes all the way, unfortunately. We say, as you know, that this agreement has these points in them, and that they flex depending on which particular subclause one looks at. The overarching point that we are making is that there are references here to advisors, legal advisors and so forth, which show that the parties knew how to refer to such persons, and that it would be very odd in our submission if the word "and agents" at the end of the definition of employee covered legal advisors.
Now, I know we're coming up to 1 o'clock. You've obviously had to contend with a lot of interventions, but your time runs out at 2:20. Would I be right in thinking we've really covered the ground, bar possibly the significance of rectification and obviously ex parte James?
My Lord, yes.
So will you manage to do those in the 20 minutes?
Yes.
That's very helpful. In which case, shall we rise now? Start again at 2 o'clock.
Right.
I'll end the last three for the short adjournment. Just a reminder,